Okay. Hello, everyone. Thank you very much for joining me. Good afternoon. This is my presentation today on the Fair Credit Reporting Act. We titled it Nobody Gets Credit During a Divorce. But really, the focus on this is combating spousal identity, identity theft, pre and post decree. Essentially, this presentation is really about recognizing the Fair Credit Reporting Act. It's an issue spotting rather than being super in depth about what the Fair Credit Reporting Act is about. We're just going to go ahead and gloss over that pretty quickly and talk about how you can recognize issues as they pop up in your practice, really in a family law context. Now, I say this with one small caveat. Basically, really, it doesn't matter if you do personal injury or bankruptcy or family law or criminal defense or even corporate defense. Obviously, people are people, and they all have families, they all have individuals around them. Identity theft is rampant, and issues along these lines are popping up in your practice. And just being vaguely, or at least have some type of casual knowledge about that this is a thing that exists, that there are solutions that are usually outside the box of what you've been typically in your practice led to believe, or remedies that are available. That is, that's going to be invaluable going forward. Anyway, so moving forward, who am I? My name is Michael Rapp. We have a small firm that focuses almost entirely on the Fair Credit Reporting Act. We blog a little bit about it. Obviously, I put the little Twitter link up there, post stories, whatever. So if you've got any questions, I'm pretty easy to find. Generally speaking, as I said, in our practice, every attorney that's here, I would say 99% of our cases have a Fair Credit Reporting Act angle, at least as count one. There might be something else, some other subsections of it, but if it doesn't have an FCRA angle to it, it's probably not a case that I would end up taking. So what do we do? Since I just said that, so if everything is FCRA, what's the whole point? Well, so I see big data companies primarily. It's not just the National Credit Reporting Agencies, which is Bullet 2, but there's a lot of different companies out there that trade in data, human reputation of different sorts. It could be driving records, it could be tenant screening, it could be criminal background checks, pre-employment screening, really anything that's public records as well. It could be judgments and liens, whatever it may be. If it relates to an individual, then chances are, and there's a report that's compiled, if someone's trading in that information, it's going to be triggered by this act one way or another. So it's not just about credit reports. It's really everything. So, and then obviously not just the big data companies themselves, but also banks, anyone who supplies the information. So banks and debt collectors, the debt buyers that are out there, aggregators of sorts, employers, car lots, really anyone who collects, in some cases, insurance companies, the data miners. There's so many different entities that exist out there that are collecting information, supplying information, compiling information, and selling it. And those are really the main target of what I do. Almost like an involuntary compliance kind of way. So the boring stuff first. Let's talk about the statute. Basically, it's called the Fair Credit Reporting Act. It's federal law put in place in the 70s. I think that calling it the Fair Credit Reporting Act is almost a massive misnomer. It's really the Fair Consumer Reputation Act. Really anything that touches on a human's reputation, that is going to be governed by this. As I said, it seems very broad. It doesn't even actually have to be written down. Someone can just, obviously really everything's written for nowadays, but the whole point though is anything that has to do with a report of some kind, written or otherwise, that talks about a person's reputation in a way that can be used in any type of financial or transactional way is going to be covered by the act. It's a pretty cool statute. It's got some good charges to it. It's got punitives, it's got attorney's fees built into it. You can get emotional distress damages without needing doctors. So also in using it in conjunction with other statutes, sometimes federal, sometimes state, they dovetail nicely together. So there you have it. Obviously, the full text of the statute's there. Accuracy is the main hallmark of it. It's got a standard in there it's pretty fun. It is maximum possible accuracy. So whoever's trading this information must have reasonable procedures to ensure maximum possible accuracy. There are state counterparts. Almost all of them are preempted. There are 13 states, Kansas being one of them, that nobody else locally here that would matter, but like California being another one, but that have state corollaries that were specifically not preempted by the introduction of the FCRA. But there it is. So moving forward, a little bit about the statute. As I said, it's really, there's so many different companies that are trading in so many different types of information that specifically relate to consumers, that specifically relate to the consumer's reputation in this financial way, in a way that one company will decide whether or not to employ or do business with or rent to or whatever it may be with that person. And they're buying this information and utilizing it. So so almost like a report card. All human reputation is essentially reduced to a 3-digit number in many cases. Anyways, so like it or not, it's there. Everyone's got one. If you've got a pulse, you have at least one and probably a half dozen or more reports that are going to be affecting you on a daily basis. So why are we here? Why is this the topic that we're talking about today? Well, in this context, my focus is going to be on identity theft. And since identity theft is on the rise, every year over year, it is the crime du jour. It is the new, knocking over a bank. There's lots of different reasons why identity theft is on the rise. But ultimately, I'll talk about this a little bit later. I think that law enforcement as a whole right now, it's a hybrid crime, really. Law enforcement as a whole doesn't really have the proper tools with which to combat it and then obviously rectify whatever damage is caused. Because as I'll talk about in a little bit, you really have a criminal. Let's just go ahead and use like the Siberian hacker, cyber burglar kind of mindset. Someone steals, AJ Steckline's identity and then goes ahead and takes out a bunch of loans and doesn't pay them back. Well, they're on his credit report, and he happens to be in Missouri, but the criminal might have taken out the loans in New York, but had all of the money sent to Atlanta, Georgia, or something like that. Just fine. So now you have all the jurisdictions in Kansas City that go all the way up to the state of Missouri, and then the federal counterparts, they're going to go over and talk to New York. They're going to go over and talk to Georgia. They're going to go all the way down to the localities and whatever jurisdictions are going to be in Atlanta, Georgia. And that's just a lot of different law enforcement jurisdictions that are going to have to interplay with each other and figure out how they're going to prosecute this case. And, for a few $1,000s, even $50,000, it may not be enough for, to move the needle for all of that cooperation and engaging that many resources just to find one cyber criminal. Especially because if AJ plays his cards right and does everything correctly and he notifies the bank in a proper way and the FTC and law enforcement and the CFPB, he can get the loan taken off from him and then it's insured by the bank and everyone just moves on. So that's the hybrid side of it, which is there's the criminal aspect of the fraud, but then the damages are resolved really through civil means. And oftentimes it can be resolved just by employment of this statute correctly. Anyways, but why are we here? That's what it is. It has to do with identity theft popping up. Um, I want to talk about the main aspect of it. When we think about, and that's the FICO score for the most part, most people, when they're thinking about credit generally, and I'm going to use just credit because it's the easiest one for us to talk about. I know I said that I do a lot when it comes to other types of human reputation, but I'm going to focus on credit because all of us have it, all of us are utilizing it, and it is definitely in the forefront of most of our minds. And it's heavily talked about and publicized and advertised. So, anyways, FICO score. It's the most common. Fair Isaac Corporation is the one that developed it. It's got an algorithm. There's lots of iterations of it. I will present this slide at the end of the presentation again and talking about it a little bit more in depth. But for the most part, this is roughly how the algorithm calculates the scoring mechanism. As you can see, what's important here is nothing talks about how much money you have. No one talks about what your income is, what your savings are, all that kind of stuff. What they're really looking at is how much credit do you have? How long have you had it? What's the makeup of the kind of credits that you have? And really, from the money you're borrowing, are you paying it on time? And the moment someone steals your identity, that can kind of throw this into disarray because now the capacity, that credit utilization, how much credit do you have available to you and how much of it are you utilizing? Well, that becomes skewed because of the fraud. And then whether or not the payment history is on there is correct, that's also another factor. So that's really what happens is when we think about it, it's not the damage so much, the immediate damage of someone saying you owe this money. It becomes a reputational harm that cascades throughout your entire life that can impact whether or not you can co-sign for your kids' student loans, refinance your mortgage, all those kind of things. It's not just about corralling the fraud in one place, but it has a chain reaction across someone's entire life. So let's talk about identity theft since we're there. I hate the term. It's a term of art for the most part, identity theft. But really, what are we talking about? Can I steal someone's ID? Can I just take AJ Steckland's ID and slap my picture over it and become AJ? No, he still goes home and still has his wife and his kids, and still can get pulled over by the cops and still get tickets. Granted, I can do those things too with my face on his identity, but really, I haven't taken anything from him. Really, what I've done is I have committed an imposter fraud. I am pretending to be someone else, pretending to be AJ, with the express purpose of stealing money from somebody. Now, maybe it's to access bank accounts, maybe it's to access credit, maybe it's to get into someone's IRAs or actually to physical location, whatever it may be. If you think about it in terms of, I haven't stolen anyone's identity. What I've really done is use their identity to commit fraud on somebody else in some other way. And that's really where this becomes so sticky, is because the identity theft victim isn't generally the victim in the real sense, because most of the time it's not their money that's stolen. They've used their identity to steal money from banks. And the banks, who know this is a huge problem and express lots and lots of concern and want to inform everyone about it and maybe even sell you products to help you preserve your identity, they're also at the same point in time, they're not interested in having their money stolen, and they want someone to be responsible for it. They don't like writing it off. So the identity theft victim has a hard time sometimes of getting getting someone to listen to their story and saying, no, I'm not a deadbeat that's trying to get out and pay my bills. This isn't me that did this. So anyways, factors for increased identity theft. What do we have here? Obviously, the rise in employment. Any financial stress causes people to steal identities. There is an ease, absolute amazing ease of attaining credit online now. Really, with somebody's information, you just click through, you promise that you're that person, but there's no fingerprints or facial retinal scans that need to be required to, no blood samples need to be supplied. It's just, put in someone's information and click send, and then poof, credit's either said yes or no to. So then you got the third piece, which is this factor that I'm just talking about here about information and the ease of obtaining credit is the massive data breaches that have happened over the past decade. It started with individuals, and then their emails were hacked, their identities were stolen, credit cards were harvested, and various means all over the place. But then people got smart and just decided to hit the databases that hold this information. And it's accelerated to the point there where most of you have heard that even Equifax, one of the national credit reporting agencies, its data firewalls were breached. And really, every living person in America, your information's been exposed. The U.S. government, the Office of Personnel Management, they were hit too. So if you're a government employee, ever were a government employee, to include the military, to include the judiciary, your information was dumped. And then if you were a resident in North America and had a credit score that Equifax was indexing, chances are your information was dumped out there too. So really, to draw a line from Fight Club, what I would say is that the survivability on a long enough timeline, the survivability rate of everyone drops to zero. So that basically means, without being super hyperbolic, because it sounds like I'm being hyperbolic, everyone is at risk for identity theft. Every one of you. And so are your clients, obviously. Again, if you have Pulse, there's a chance that your identity is going to be stolen at some point in time and utilized for something. And some people, though, are even greater risk than the great risk that we're already at, which is they might be at increased risk for various other reasons, and one of which can be in divorce, and we'll talk about why in a second. So really, there's mainly two types of identity thieves out there. There is the total stranger, who is going to be a cyberspace burglar, going to have this information available to them. They've hacked it or purchased it from some dark web, Spice Road kind of, pseudo website that you can only reach, if you have the right equipment and you're buying it from some nefarious character, in Siberia, or it's someone who knows you or knows the victim. It's a family member, spouse, ex-spouse, coworker, friend, ex-friend, cousin, brother, sister, something, who knows? Somebody who is intimate enough with them one way or another to have access to the information. And you know what? It might actually be somebody that's sitting there at a you break, we fix kind of, cell phone repair shop, or they might be able to gain access to your information because they got the right Apple login because they have access to your device, or it might be somebody that you work with and they're in charge of the HR department or work in the HR department and they steal it. And but it's someone connected to you or the complete stranger. So the second one, obviously we all look over and say, look, I never had this account, or someone hacked all my stuff, whatever. That's probably enough. But the other layer that's more complicated here is when it's a friendly fraud. This person that's close to you. As I'm looking through section 2, that's what we call it, as friendly fraud. It's because it's somebody that is somehow close enough to you that it complicates the investigatory process from either the bank or the creditor, or even the law enforcement when they look at it. It complicates it for various reasons, but which we'll go into. But anyway, it's common. So it's probably even more common than anything else. And when you start seeing these addresses that popping up, and it's happening in the same zip code, and these purchases are made near where you'd otherwise be shopping, it becomes harder, especially if it's a child or a parent, or now an ex-spouse or significant other that has been stealing this money and trying to get you to hold the bag. It looks more and more like maybe you just lent your ID to somebody and now you don't want to pay the bill. So there's that. So it becomes harder to push that boulder up a hill. And then the last one is, again, when it's family or friendly or whatever, and it becomes complicated and it's a he said, she said, the police aren't really like well equipped to deal with it to begin with, and then they might not be interested in injecting themselves in between, two ex-spouses about who stole what from whom and why, and it becomes, again, he said, she said, that they don't have time for it. Okay, so why are we here again? What's the point of this? So the first one is obviously when you have a divorce going on. This is an emotionally, again, we're talking about identity theft in this pre and post decree kind of concept. What we're talking about is a hyper emotional point in people's lives, and they could at this moment are the most at risk for identity theft, or some of the most at risk, I should say. Again, being too hyperbolic. And then number two is even accidentally knowing what they are allowed to do and what they're not allowed to do is important, because they might not be attempting to break the law or steal identity, but they need to know that that they need to be cautious, one, for themselves, and two, not to do things that could otherwise get them into trouble later. So when we talked about this, this is basically the perfect formula for identity theft. This moment in their lives of dissolving a marriage is emotionally charged with a person who has a lot of intimate knowledge of their personal information. So you've got the hard feelings, maybe a sense of entitlement, and this is a person who knows your birthday and maybe the type of keywords that you use for passwords. They are going to know your social security number. They're going to know what are the loans you've taken out, all the stuff to prove who they are or that they are you at that moment. And so it makes it very easy to steal identity. So for both sides. So anyways, so what do you do? What are we talking about here? Most of the time when I have posed this question, again, going back to what I deal a lot with identity theft, but I deal a lot with anything having to do with reputation in general. So not all of it's there. And as I've talked to other people that see and spot these things in their practices, just fair credit reporting related issues, one of the things that I've asked of family law practitioners is what happens when, let's say, you've got a client that comes to you, it's a year, maybe two after the end of a divorce, and decree's already put into place, spouse support is being paid, maybe like that house was refinanced and credit cards were closed and paid off, or maybe they sold the house, whatever it may be, and they've gone their separate ways. What happens when that same client comes back to you and she says, I went to go buy a car the other day, and a credit card that I know I paid off and we zeroed out at the end of the divorce has been reopened and has a $10,000 balance on it. And I didn't do any of these things. And I'm pretty sure that deadbeat that I divorced, a year ago, he's restarted that card because I think that's his address that I saw on my credit report. And I haven't seen any of these bills. And I tried calling the credit card company, and they said that I changed my address a year ago or 6 months ago or whatever it is. What do you do at that point? And most of the time, what people say is, oh, I tell the judge, or go in and you have to reopen, and my client's got to pay me some money, or I'm gonna eat the cost for it, because I feel real badly, and we go in and get a contempt order in place because they're restarting things or whatever it may be, and try to get them responsible to pay for it. But the thing is, these divorce decrees don't have any legal effect on these contracts. This is between two private parties, and these are, going back to property law, which is first in right is first in time. Well, these are all going to be subordinate to whatever those contracts are. So if she was a sole signator on there to begin with, they're going to hold her responsible regardless of what the judge says. They're not going to go ahead and start suing him instead because he's not on the contract. So as far as they're concerned, it's her debt. and they're not going to change that just because a divorce judge says otherwise. So you're then charging your client or eating the cost to go ahead and get an empty piece of paper to get someone to pay a bill, which they probably don't have any money for in the first place, which is why they were stealing her identity. So the reason what we're talking about here is to really give you another set of tools to help protect your client, to understand that as sophisticated as everybody is, the judge and that divorce decree isn't going to do anything to basically keep your client's reputation from being dinged by the actions of their ex. And even if the judge does step in and it is a painless process, boom, hearing the next day, do it for free, you're already there anyway, and there's no contest, and then they just go, yep, that belongs to the ex-husband. It doesn't really necessarily fix the credit problem, because all the late payments are still going to be on her credit report, and it's still going to be an issue, and there it is. So what we believe, and I'm going to put this here, probably shouldn't put the whole thing in red, is setting out disputes early, often, to the credit reporting agencies, to the bank itself, is imperative. You want to go ahead and set up a record as fast as possible, as you possibly can, putting it on paper, putting everyone on notice. Hey, look, this is not her debt, and she shouldn't have to pay this. You guys are on notice. Her identity's been stolen. And that will become more apparent why in just a little bit. So anyways, so what I really want to talk about is, you got a client that walks your door. In a perfect world, we would do everything right from the outset, before they ever even hand you over money for a retainer, before you do anything. You could go ahead and have a whole ton of information in front of you and make all the right choices. A lot of you guys are going to have cases that are going to be ongoing. Clients should come back years later, and long after this presentation, or long before this presentation has even happened, whatever it may be. So now moving forward, we're going to make things a little bit easier on you. But this is my suggestion: get a baseline of their credit. You're going to do that no matter what. Obviously, you want to do it before the decree, ideally, but whenever somebody comes in and says anything about anything that has anything to do with their financial reputation, and I'm just going to keep saying credit, regardless of whatever the problem is, whether or not it's they say I've got an eviction, I don't have it, I have this ticket, or I was arrested and I wasn't there, whatever it may be. We're just going to use credit as a perfect euphemism here, okay, or at least stand in. So you want to get a baseline of exactly where they stand right now. The best thing to do is run the reports. Get a copy of whatever it's going to be as fast as possible to see what is it saying about them today. In the credit report context, there was a law that was made, it was passed a little while back, that I think it was in 2004, was the FACTA Act, that basically said that people have a right to look at their own credit reports once a year for free if they ask for it. And the national credit reporting agencies, the NCRAs, got together and made this website called annualcreditreport.com. And then you can get all three through there. And generally speaking, you can get it once a year for free if you ask for it in writing, and asking for it off that website counts. I would recommend that when you get it, you immediately save it as a PDF, because they do vanish and blah, blah, blah. These things are not permanent. They're just snapshots in time. And they like snapshots, they can fade away if you don't save them. But so there's that. I also suggest getting I always mail off. You can't actually get it through the website, but you can, and they don't do it digitally at all. They will mail you this large ream of paper, LexisNexis, if you request it in writing, send it off to them, and then they will mail you something back, which is rather much more expensive than most credit reports. Excuse me, than most of the NCRA's credit reports, because it covers a lot more information, because Lexis buys and sells a lot more information than just the credit reporting agencies do. So anyways, if I get all of those, that's the place that I would start. You get that baseline, you figure out what information you know about them, and you go forward from there. One thing I would talk about when we think about the Fair Credit Reporting Act, before I talk about the slide at all, is one thing to keep in mind is that we, as in the consumers that are governed by this act, or at least included or thought of by Congress here, um, are not the consumers of this information. We are not the customers of the big data companies that trade in the information. We're actually the product. And so our reputation is the product that they're buying and selling. So we have a very strange interest in the integrity of this data, even more so than the CRAs themselves. If you were talking about grain, individual stocks of something, or whatever it may be, individual ears of corn, let's say, for example, that's really what we are. And so, they have so many of them moving through their system that they're almost using us to scrub their data of mistakes in many ways. So, us being vigilant in our own reputation is helpful to them, and obviously very helpful to us. But anyway, so what I would start with is once you get the baseline, then you can educate and warn your client. Obviously, they're focusing on other things. They've got this entire divorce in front of them. They're going to have to figure out who's going to have child custody and, who gets the house and the cars and the debt. And that's where their immediate focus is. They're not thinking about the horrible things that the person that they spend so much time with is capable of doing. And any of these things, if they go into collections or what have you, they could pop into causing them damage for 7.5 to 10 years later. That's a long time, and often has much longer than after the smoke clears from whatever happened from the mirrors that just cratered. So they're looking at it very myopically right in front of them, and not able to focus on the bigger, longer term picture. And so being able to help them see that this is something that is important, and to deal with their financial health is obviously is a great piece of counseling. So what do you do in order to accomplish that? Well, my first thing is, I believe that once you have the baseline, you know what the credit report says today, you know what information that's on there that is either obsolete, ugly, or incorrect, and you can do something about that then and fix it. Well, then once that happens, it's not a fire and forget process, because this is a living, breathing document. These databases are constantly getting new information in them, and new reports are being created. So you need to have something in there to monitor what the health of your client's reputation is. You can buy a product from any one of the NCRAs. Experian, I think, does it, is probably one of the most prolific when it comes to their advertising. In fact, I think even the product that you buy from Costco is an Experian product. Anyways, there's going to be an arbitration agreement in there, where if your client's a victim of identity theft, generally speaking, there won't be arbitration agreements, and you'll be able to seek redress in court if they don't do their jobs, and when it comes time to being notified and fixing it. But even in case of because almost everything we touch has an arbitration agreement in there. But it wouldn't be if your client wasn't the signer of the contract. Their identity was appropriated to create these contracts. So they're not going to be bound by the terms of the agreement. They're going to be just bound by the law itself that says this is how you fix identity theft. But the second that you learn about it through a credit monitoring service, there's a very good chance that might trigger an arbitration agreement there. So now you've opted one of your possible defendants out, and that's may or may not be a place you want to be. But being aware of it's there. I personally don't want to be. I don't necessarily want to be in arbitration with any of the NCRAs. I'd prefer to be in federal court for lots of reasons, but sometimes it does make sense to be in arbitration. But that is neither here nor there, especially knowing it's there is one piece. The other one is the same is going to be true when you use the credit monitoring services that are given free from your bank credit cards. again, it becomes tricky about when the arbitration agreement would attach and how it would attach and what pieces are in there or not. I believe that when you're learning about it through the monitoring service, you're going to be triggering that arbitration agreement and pulling it back in there. So that's not my recommendation. Like LifeLock, ironically, buys all their information from Equifax and profited immensely. Both of them did from that data breach. Obviously, there was huge payouts, but suddenly everyone rushed to LifeLock because it was such a well-known name. It's been around forever. It definitely has first mover advantage. Very well funded when it comes to their advertising campaigns, and they definitely charge for it. I think that it is the most expensive product on the market. I don't think that they add any features that are unique or different. I mean, I guess now they work together with Symantec or something like that, and then they give you antiviral software too. But for the most part, I don't think that the product, when it comes to LifeLock itself, is any better than anything else that's out there, or not significantly better than most of what's out there. And you're going to pay 2 to 3 times what you'd pay from anybody else. So not my first suggestion. The fourth one's on there is a high-risk monitoring service, Eagle on Watch. And in the interest of full disclosure, I will definitely tell you I have an interest in that company, so that's fine. But the main reason why we built it was for the reason of getting rid of those arbitration agreements and not having a service that could otherwise be considered a credit reporting agency, because it doesn't actually sell information for any purposes other than letting consumers access it. So there's lots of reasons to use it. I'm not going to go into tons of it. If you're interested in that particular one, feel free to contact me. But there's lots of choices out there. I would just be wary of the arbitration agreements first off, and not buy anything either directly from a bank or directly from one of the credit reporting agencies. I would look for something like LifeLock, but less expensive without an arbitration agreement. Okay, so credit basics are really what's kind of important for most of us lawyers to have. You know, we're used to writing a letter to someone and having them fix things, or at least wake up and have an adult take notice that there's a problem. All of these companies, the banks, all the lenders, all the CRAs, they're so large that some podunk lawyer from Missouri isn't really going to set off any alarms for them. So the letter doesn't necessarily even get read by a human. It's probably going to be scanned in, indexed in some file somewhere. So that's piece number one. Knowing that is real is the first step. The second thing is you have to, once you realize that we don't have special powers of persuasion with these mega corporations, then you look over and say, what is the procedure by which you communicate with them, and how do we get things fixed? The second point is probably the most important one that you can take away from this presentation, and that is, no matter what, if you're going to dispute something that is ugly or obsolete or flat out wrong that's on a credit report, you absolutely have got to send that dispute to the credit reporting agency, period, credit bureau. So if something's wrong on Equifax reports, send it to Equifax first. Even though it's Chase Bank saying something is not real, you got to send it to the bureau itself. Otherwise, you're going to have some problems. So the thing, though, is you should also send it to Chase. That could trigger things under different statutes. Could be a NECOA thing, could be the Fair Credit Billing Act or TILA. It could be a lot of different things that would be triggered by it. It might even be a Miller v. Nelson letter deemed under the Kansas Consumer Protection Act. Whatever the case is, sending something to the furnisher is an also ran. Notifying the credit bureaus is the absolute must. And here's really the reason why. Because the way the statute is constructed, it basically says that whoever furnishes the information can only give information to a CRA that is been vetted, that it is accurate. Not supposed to give off inaccurate information. But there's no private right of action under that part of the statute. That does not give you a right to sue them for furnishing inaccurate information. The credit reporting agencies must have procedures in place to ensure that information is accurate. And then if they get notified from a consumer that there's an issue, then they have 30 days to conduct a reasonable reinvestigation of that information they already deemed to be accurate. So if you as the consumer don't notify the CRA to trigger that 30-day piece, you only tell the creditor directly, you've not triggered the act in a way that you can do anything about because you haven't notified the CRA. Therefore, you haven't started the statutory period, no investigation takes place, and the furnisher can basically giggle at you and move on, and the problem is not solved. If you are notifying the furnisher, I would do so in conjunction with notifying the CRA. That kind of puts everyone on notice. Investigations have to take place, blah, blah, blah. Anyways, but that's the big piece here. That's the big takeaway. So if anyone's actually taking notes or cares about this stuff, note that you have to notify the CRA before you tell anybody else. You can also do the other. You can also tell the creditor, no problem with that, the furnisher the information. I'm okay with this. Just make sure you're telling the CRA. So here's what we've got. Let's put together a good checklist for things so that good takeaways. We got about 10 minutes left in this of what happens when a person comes into your office, and we're going to go ahead and just use the divorce context here. They walk in, even before you know you've got a problem, or even if there's no problem at all. What is the steps that you should employ in your practice to make sure that you are covering this base correctly? All right, so as I say, plan your work plan. All right, pull your client's credit report. This is something I talked about before, but here we are. So you get your at least report from all the NCRAs, which is Experian, TransUnion, Equifax, annual credit reports. Perfect for that. Get a copy of those. You scan it, you look at it, you try to figure out if anything on there is ugly or obsolete or incorrect, and then you move on from there. Second piece, check and make sure that, so as I just said, you want to look on the report itself to see whether or not the first step will be addresses and phone numbers. Do you see anything on there, or does your client see anything on there they don't recognize? That's not my address. That's a work address. That's my ex-spouse's parents' address. That's not going to happen. Anyways, so those phone numbers are mine, whatever it may be. That's the first layer of your dispute. This stuff is incorrect. Next piece, identify all the accounts that are in your client's name. Now, there are lots of possible, six possibilities of how an account could put together. It could be solely in your client's name. It could not be in your client's name at all, and they're just an authorized user on it. It could be jointly in their name and their soon-to-be ex-spouse's name. It could be between them and some other people. It could be not something that they're part of at all, and there's been added on a credit card from a friend or a relative. But ultimately, you need to identify the accounts that it's just their social security number that is securing this loan. So if they go in and they applied for an American Express credit card and they get supplied it with only their social security number and no other cosigners, no other joint obligors, that's in the accounts you want to know about. Okay, so that's category one. Next category, identify all the accounts are joint. So cosigners, you both signed for a loan. You both signed for buying that car. Both of you are on the and it'll say on there joint rather than individual liability. But you want to identify which ones are those. The other thing you want to identify is prior to filing your petition for divorce. So you want to figure out exactly everything that's in your client's name, everything that's in your that's in both of their names, and then you want to identify everything that they're an authorized user on. Again, it says joint, individual, or authorized user. Once you know they're an authorized user, that basically means that this is not an account that's in their name. It's an account that is solely and completely in their spouse's name. And then what I would do once you have that information is that's when I would employ the monitoring service. You now have a baseline. You know exactly what's occurred. You know exactly what the temperature is. You can see something. So even if, let's just say the spouse, when you do file the petition, comes forward and says, no, I only have this one credit card. You go, well, our credit report shows you got a lot. There's like 6 other ones that I'm automatically added on to. Oh, that's another fun feature that I should throw out there right now. There is some, I cannot remember if it's it's a banking law or I think it's a regulation that basically says the Equal Credit Opportunity Act. Or it's an FFIEC regulation. But anyways, I digress. Point is, you married couples automatically, if the bank has knowledge, makes the other an authorized user. So that's worth noting. Because if it's you're going to want to go ahead and get that owner off of there. Well, the reason I say that is because there is an interesting quirk when it comes to credit reporting and banking. Let's say I have an 18-year-old son. He's heading off to college. He has zero credit up until this point, doesn't have a car, has never really even had anything in his own name. And I want to help him get a good start. Use secured credit options, give some money to the bank in a CD and issue a credit card up to that amount, blah, blah, blah. That's one way of doing it. It operates like a credit card, but it's secured by, a bank account. That's one way. Another way is to just make them an authorized user on my credit card. If they get their own card, they can use it. I'm on the hook for all the purchases. But my credit history on that account becomes something that piggybacks onto them. And in that case, it's a very good thing. That will lift my son's credit and his credit score from being practically zero to nothing at all. Even though he's not an obligor on this, it does give him a lift. It shows good credit history. That's one way of building it. So when you actually are an authorized user on your soon-to-be ex-spouse's credit, who knows? They might have better credit than you. But the second that they stop paying on it, you take the good, you get the good, you take the bad, and you take them both, and that's what you have the facts of life. So if they start screwing up their credit, it'll impact you as well. This happens a lot in the context of parents and elderly parents and children. They might make a child an authorized user and help them pay for expenses, but as they're getting closer to exiting the moral coil, they may not be taking credit as seriously and paying their bills as regularly, what have you, making decisions on how they're saving money and what debts they're not going to repay, and it could actually tank their kids' credit. So anyways, worth noting. Okay, so during divorce proceedings, obviously you want to regularly check for any alerts, address changes, or new credit inquiries. We've already got the baseline, we've got the monitoring in place, and we know that if anything new that pops out, anything that doesn't belong on there, anything that changes that is not something that they have actually engaged in, then poof, there you are. You get an immediate alert for it, and so you're being more proactive in dealing with the damages. So if there is a problem and you do disputes, then doing those disputes there, you want to document them. Make sure you keep copies of everything. You make them as robust as possible. Include whatever documentation you may have. Blah blah blah. The third thing down here is freezing credit. I put a question mark at that because that is a point of some contention. I had a client who did a credit freeze, and the identity thieves knew him, and they did so because his identity was regularly stolen. But they knew him so well that they were actually able to get in behind that firewall and change the phone numbers. Because what basically you're doing by a credit freeze is putting together a firewall, and it's a double authentication process. So you apply for credit, you have to have all the information, then they give you a phone call and ask you whether or not this is really you that's applying. And that's usually in the ask for a PIN, you may have that, and boom, then you move forward, and that's how it works. The basic factor here is that once they can get in behind it, they can actually change. They change that phone number to them, and then he was locked out of using own credit. So it is a risk that's there. You can basically not be able to use your own credit. But I digress. So what do you do after post decree? You take all those joint accounts that they were a part of, and you close them. You don't want to be connected to this person where you have joint and several liability on a loan. Second piece is that I would take and go to anything that was on my own individual. I would immediately ask for a brand new number. that is going to kill it from your Amazon account or this, that, or the other thing, whatever they may still have access to. Get a new credit card number, new PIN numbers, new stuff, and that's going to help. Obviously, you want to notify the banks directly of your divorce so that it will and request that they cancel any and all authorized users by this name. So there's that, which is the last thing. Remove all authorized users off of the account. And then obviously you still have this monitoring service in place and use it for a long, long time because you're going to need it, and you'll know if there's any changes or credit inquiries that happen at some point in time. I think that I'm actually pretty much out of time here. I do have 2 more slides, so I'll go through these super fast, but I want to go back to the FICO score. And it's a point worth noting, which is when you close so one of the things here is length of credit history. That is that third one down in the legend. It's the green one. It's 15% roughly of what the FICO score is. Basically, if they have been married forever and they've had this joint account forever, when they close it, it's going to impact them. Also, capacity used. This whole concept here is credit capacity, and it's a utilization score, which is if I've got $50,000 in possible credit in front of me and I just close a $20,000 credit card, then I'm now went from 50 to 30. And so whatever my balances are going to negatively impact that. And so my credit score will go down. And that's something you have to let them know. But you have to ask yourself, do you want to have your inextricably linked on this joint loan forever with the person you're divorcing? Or would you like to go ahead and just take the credit hit for the time being and then bounce back? Or maybe apply for new credit before you cancel it, whatever it may be, blah, blah, blah. There's planning things that you can do. Anyway, so that is my presentation. Again, feel free to contact me with any questions. I went through this pretty fast. This is not for as simple as the statute appears to be. It can be somewhat complicated. I didn't discuss about how you bring the federal lawsuits and what you need to worry about when it comes to new standard requirements because of Supreme Court cases have come out, such as Spokio or TransUnion Ramirez case that was just decided 3 weeks ago. That again have to do with Article 3 standing. I can talk about that stuff ad nauseum, as anyone who knows me will tell you. But this is us. This is how you get in touch with us, and I'm here to answer questions whenever you'd like. All the best, and thank you very much. And you guys have a nice day.